Live with you from Omega Live TV. As you know, I hope by now, my name is Linda Appiah and I am a barrister. Now I practice in England and Wales and also in Ghana. So this evening's topic, I encourage everybody to get involved and contact me to answer your questions. Now we're coming to you live, as I said, from Omega Live TV, and I need to give a shout out to our sponsors. Our first sponsor is World Remit. Hopefully most of you should know who that is by now. For all your money transfer needs, they have an app as well for convenience, so you can send your money back home to your family and to your friends. And our second sponsor this evening, who hopefully his name will come up on the screen, is Cox Mech Cocktails, and their phone number is 07738 285316, and I'll mention them again at the end of the show. Okay, so of course I'm here with you to discuss the law, to help you, give you some support, give you some ideas on how to resolve legal issues that you may have. And every 2 weeks, for those who follow me know that we have a different topic every 2 weeks and we discuss different issues, and I bring with me some colleagues to help us discuss those issues and to go through some of the things that they have come across in their own practice. Now, as you know, you can contact me by posting your question on our Facebook page. We'll not do it by phone number this evening, but we'll do it by questions on our Facebook page. So either on Omega Live, post your questions there, or for those of you that follow me, Linda Appiah, you can post your questions on my Facebook page. All right? So good, let's get cracking. If I tell you first the topic for this evening, we are doing landlord and tenant. So we're talking about the relationships between a landlord and a person that he rents property out to, and that's his tenant. And specifically we're dealing with residential landlords, so not commercial property, not for those who are renting a shop or something, but a place that you call home or a place that you reside. And we'll deal specifically with an issue I know a lot of people have a problem with and stresses a lot of people out, whether you be the landlord or the tenant, and that is possession. Yeah, and I'll explain what possession is with the help of my guests this evening. So I have two great guests who are colleagues of mine that I've worked with on and off for many years now, and they are from Simon Noble Solicitors. The first guest is Cecilia Mwaheng Tufor, and she is a solicitor and partner of Simon Noble Solicitors. The second guest is Dennis Tufor, who is also a solicitor and also the senior partner at Simon Noble Solicitors. So I want to say, before I talk anymore, hello to my guests this evening.
Hello.
Hello, how are you both this evening?
Oh, yeah, very well.
Good.
Very well.
Good. Well, we've had a look at, haven't we, at what topic we're going to discuss this evening. And we decided that one of the ones where a lot of us get a lot of questions from our various clients is in the area of landlord and tenant. So us having a landlord as a client or having a tenant as a client. What are the issues that they like us to deal with, and some questions that they've put to me already that I'll ask the two of you to help me with to answer for the viewers. Okay, so if we start off, I suppose for us it's a basic question, but for the viewer just to set the scene. If you don't mind, if I start with you, Dennis, first of all, what would you say is possession? What are we talking about here?
Okay, thank you, Linda, for inviting us this evening. What I would say, possession is a way landlord takes the property back from the tenant. So as Linda said initially, is that's the relationship between tenant and landlord, is landlord giving property back to the tenant, tenant living there using as their home, principal home, for a specific time, and then landlord now wanting to take the property back. And that is what possession is all about. So it's just landlord taking back the property from the tenant.
So it's that process, isn't it?
That kind of process here that the landlord has to go through to get that property back here.
Okay, well that's helpful, because I think that will help the viewers understand what exactly we're going to be talking about.
Correct, yeah.
Because Cecilia, I think you'll agree that that's probably the outline of it, isn't it?
That is the outline of it.
Yeah,
yes.
exactly.
Yes.
So, and that seems to be a relatively straightforward question. So thank you, Dennis, for that, because that will help people a lot.
For that question, At the moment, as we know, with the issue of COVID-19, most landlords have been having an issue where the tenant have not been paying the rent. Therefore, the landlord may have to seek possession because of rent arrears. That will be one of the reasons why the landlord will be seeking the possession of the property.
Yes.
On the other hand, where the tenancy agreement has ended and the landlord seek the possession of the property, then that will be another reason. And if you don't mind, Dennis, you can add more to those reasons.
And to add on to what Cecilia just said, landlord can also seek possession of a property if the tenant has actually breached any of the terms of the tenancy agreement. So that could be probably there is antisocial behavior by the tenant. The landlord
so
can
troublesome
tenants, yes. So landlord can seek possession of a property. Or sometimes if landlord used to live in a property and they want to come back in, then they can also try to seek possession because they used to live there and now they want to come back in. And one of the things that a landlord can also, one of the reasons is because sometimes the property might be needing repairs. The landlord needs to repair that property, but then for the tenant to be in there, if it's going to be inconveniencing the tenant, the landlord can also seek possession. But this is one of the things whereby the law on that area is a quite grey area where that actually asks the landlord to maybe rehouse the tenant on a different property and then repair the property. But then sometimes landlords try to use those grounds to get possession of property. So to summarize what we just said, so it could be like the tenant has failed to pay rent. And normally, what the law states on that one is if you don't pay rent for your rent arrears for 8 weeks, if you pay weekly, or 2 months if you pay monthly. So if your arrears on either 8 weeks or 2 months, the landlord has got right to seek possession of the property. And then with that, when landlord starts seeking possession on that grounds, then the problem that the tenant faces is the court doesn't have any discretion on those ones. So the landlord cannot obtain possession easily on those grounds. The other one that Cecilia also said is, if the tenancy agreement is ended. So the tenancy agreement is ended and landlord want to now come back and take possession, the one they can get. And that too, there's no discretion. Landlord can get that because, it's clearly states that your tenancy agreement is finished and then they want to come back on the property. The other one that I just said about, if there's a troublesome tenant or a landlord want to come back to the property because they used to live, those ones somehow kind of discretionary grounds. It all depends on the court. You have to satisfy the court that you done what it takes to you done something to show the court that you have that right to get possession of property, but that is discretion. So I think these are actually one of
no, I'd agree with you. I know there's also, in addition to the rent being not paying the rent, there's also the issue of paying rent habitually late.
Correct, yes.
So there's also that side to do with the rent, isn't there?
Yeah.
Yes.
And I agree with you. I think one of the things that I find with my clients is that they tend to, and this is on the landlord side, they tend to want the property back because the tenant is a pain on one level or another, and they want the quickest and easiest way to get rid of the person so they can take the property back and rehouse it, relet the property or whatever.
Yeah.
That brings me on to a question that actually one of my somebody contacted me earlier on and asked whilst I was on the way here actually, and the question is, we talked about a tenancy agreement. Now sometimes people have them and sometimes they don't. What's your general advice or your view actually about the necessity for a tenancy agreement? Cecilia, do you want to answer that one? Do you think you need a tenancy agreement?
I would say it is important to have a tenancy agreement because having a tenancy agreement, it sets out the terms clearly. First of all, in terms of when the rent is due, how often you have to pay the rent, whether it's going to be weekly or monthly. But then also it tells you your rights as a tenant and your responsibility, and also your kind of as a landlord, what are your responsibility, and also how you can, and then on what circumstances can you get your property back.
Exactly.
However, not having a tenancy agreement per se does not mean you are not a tenant.
Okay.
There is also a test
Yes.
that has been set that is distinguished between anybody else who is probably a licensee or a trespasser to a tenant. I will look at the fact that if, let's say, you have the property that you live in, you pay monthly or you pay a rent on a monthly basis, and you've got exclusive possession, then it could be implied that you're already a tenant.
You're getting a bit technical,
Oh,
right?
okay.
Because I can hear you using all the terms.
Let me just go back. Implied means like it will be seen that you're a tenant.
Yes.
If you have got the property,
Yes.
you pay the rent on a monthly basis.
Yes.
You live there by yourself or with your family.
Yes.
The landlord cannot come and tell you when to put the lights off, or
Yes.
the landlord cannot come in and go as they please.
Yes.
Then that gives you.
It means you have that, what you call exclusive possession, which is the exclusive, so the sole right.
Yes, yes,
Can I put it that
yes,
way?
yes,
The
yes.
sole right to actually
to that
stay
property.
in that property.
Yes.
So if a landlord wants to get you out, that's when we have to start going through the proceedings, isn't it?
Yes.
Which is why I think your advice is, look, it's probably better to get a tenancy agreement.
Yes.
Everything's clear. People
Yes.
don't get confused. If there's a rent increase, put it in writing.
Absolutely.
Put everything in writing. These days, if you don't have things in writing, people can say whatever they like. Yeah.
The whole thing is like, at the moment, which we come across a lot, most of our clients are estate agents, property management companies, and other individual landlords who've got properties. You'd find that sometimes some of the tenants would end up subletting their property, and then you find it difficult for them to actually get possession.
Yes.
In which case, where they have already given a tenancy agreement is something that you can say, you know, I gave tenancy agreement to this particular person
Exactly.
on these particular terms. Therefore, when you go to court, you've got a leg to stand on.
Yes. Yes.
So
Yes. And I think courts tend to take you more seriously if you've got a tenancy agreement.
That's
If you
very
don't, they sort of look and think, well, this slapdash way of dealing with what is in essence a business.
yes,
I'm not entirely sure the courts are convinced sometimes, and probably wonder what else, unless it's a person who maybe was a family member or a friend, in which case they may understand. But if it's someone who you've known, I don't know, from here or there, why not create certainty through a tenancy agreement? Is there a disadvantage, do you think, Dennis, if there is no tenancy agreement and you're trying to seek possession, for example? Is there anything about the proceedings?
Yes, there is. So let's assume that there is no tenancy agreement, and that you want to take possession of a property. Let's say you say, okay, it's because you've got different types of proceedings you can go by. So you can go under section 21, which I think we'll explain it later
Yes,
on.
yes.
Or what that means, the tenancy has come to an end and you want to take the property back.
Yes.
But then without a written contract, how do we know that the tenancy has come to an end?
To an end, indeed.
How do you know what's the length of the tenancy you're
Yes.
giving to your client, to your tenant?
Yes.
You don't know that. So that now becomes a challenge or an issue that the court has to deal with. And when it comes to those things, it's just something that the court will take, whoever's what do you call it? Their fact actually
Makes sense to the
sense
court.
to the court.
Yeah.
And that's what the court is going to be looking at. That's what. The second thing is, if you want to seek possession on the basis that there is no rent, there is a rent arrears, then the tenant can now challenge you to say, I don't have rent arrears because I have to pay you £500 a month, but then you also claim me £600 a month. What is the evidence?
Exactly.
So there's no evidence. So it becomes a battlefield that we have to have to overcome it.
Yes.
So it's actually vital that there is a tenancy agreement, a written tenancy agreement, which sets out, as Cecilia said, all the parties' intentions. Everything is clear. Nobody is beaten about the bush. It's all there, clear cut.
Indeed. It brings to mind actually a client that I had before, who I think at the point they were family friends, and I was acting on behalf of the tenant, and the landlord wanted possession of the property because the tenant wasn't paying rent, and we were, by the time the tenant came to me, I think he was in arrears 6 months, £1,000 a month. That's a lot of money.
It is.
And to be honest, I think he had just dug his heels in. Even though he was my client, I could see and look at it and think, well, what's the justification for not paying your rent? And the tenant said to me, well, he hasn't done this in the property, he hasn't done that in the property, different things in the property. But at the end of the day, the landlord just simply needed to serve the proper notice, which we'll come on to now, and give it to the tenant. And what's your argument? You don't have one.
You don't have one.
The only issue was whether there was a tenancy agreement. So, of course, when I asked my client, the tenant, is there a tenancy agreement? No, there isn't one. And the landlord suddenly produced a tenancy agreement with my client's signature. Well, what looked like my client's signature. And then you have to advise and say, look, come on.
Yeah.
You might be trying on not want to pay rent, etc. But, you had a good game. You had 6 months free rent. Why don't you just move out and find another property? But then we've got the social housing problems, which again we've chatted about already. So if I just move on to the next question. So you've got a tenant, a pain in the so-and-so, not paying rent, you've had enough, you want them out, they're owing you, as in my client's case, £6,000. Okay, 6 months, you've been knocking on the door, you've been getting frustrated, your hair's turned white, not even grey, because you've just had enough of them. What do you do? What's the first thing you should be telling the tenant, apart from moaning at them and calling them and generally letting them know that you're not happy with the situation? Dennis, what do you advise? Yes,
thank you. Yeah, so on this one, I think what the law actually asks you to do is to serve them a notice, that you are seeking possession of the property on the basis that they fail to pay rent.
Okay, so sorry, Dennis, but when you say serve them a notice, that means give them. Are you talking about send them?
Yes, so you have to send. You have to send this. Basically, you have to act for, give them a letter or something that you want the property back because they haven't paid rent, and that particular notice that you're given, I think there is a prescribed form that you have to use. And I think we come back later in terms of what issues that the landlord are facing on this. There's a prescribed form that you have to use.
Okay.
And that form have to clearly state how much arrears they are.
Yes.
And then when are you going to make application to court to evict them? But as Cecilia said earlier on, is because of this Coronavirus Act, things have changed. It used to be 14 days notice that you have to give in terms of rent arrears, but now it's all changed to 6 months now. So,
it's a big jump.
It's a big jump. It's a big jump. It's a big jump. So it's 6 months. So you have to give them that 6 month notice, and then after the 6 months, if they still haven't paid the rent arrears, then you can now go to court. You can now go to court and evict them. So the first thing is send them a notice. Telling them that if they don't pay your outstanding rent arrears, you take them to court. And you've got to make sure you're using the correct. The correct form.
It's exactly.
Very, very important.
And then to see if I can ask you, Dennis has talked about serving them a notice. So we're talking about. Section 21 was also alluded to, I think, earlier on. That we know there to be 2 types, depending on what the problem is, in terms of the types of notices that you serve on your tenants. When would you normally serve what's called in the industry a Section 21 notice instead of a Section 8 notice?
Okay, I think adding to what Dennis have just said, Section 8 notice, you serve it when there's rent arrears, antisocial behaviors. However, Section 21, you serve it when the tenancy has come to an end.
Yes, and you just want the property back.
You just want the property back.
You don't need to give any excuses. You don't need to go into too much detail. You just say, I'm the landlord, I want your property back.
It's now, we gave you 12 months and then 12 months is up. So I'm not going to be renewing your tenancy agreement. I will need my property back.
Exactly.
Yeah. And also, I think there is another thing that you can also do in case. Sometimes, not everybody is a tenant.
Yes.
So some people are not tenant and you want to get rid of them for the property, then you don't have to use Section 21 because Section 21 is just for tenant,
Yes.
the tenancy has come to an end. Not Section 8, because Section 8 is also for tenant when, as Cecilia said, there's a rent arrears or there's an antisocial behavior. But there's another one which is a notice to quit.
Yes.
Now, the notice to quit is just for people like trespassers. There's somebody living in the property that you don't know who the person is. You want to quit them, or sometimes is a kind of a short agreement that you give in to the tenant that you want them to out. But then I think probably next time we have to just talk about who is a tenant and who is not a tenant.
What's a tenant, what's not a tenant, because then that's I agree. I did possession a few weeks ago, but I did it in combination looking at the immigration issues in relation to possession, unlawful eviction and immigration law. And one of the questions that actually I had arising out of that program was somebody who wasn't sure whether the person who was staying in her property was actually lawfully in the UK or not. So in the event that she found out she wasn't, does she need to go through this Section 21 and Section 8 procedure in order to get that person out of the property?
I think with that one, I think the immigration law makes it quite clear that if I'm not gonna say thank you Theresa May, but that's something she brought all these things. This was a hostile environment. All this. So all this thing came out of that hostile environment. So now what's happened is that what would they say? If you don't have right to remain in the country, then you don't have right to rent. And then I think the immigration rules actually made it clear that if somebody who doesn't have those kind of rights, they cannot rent. So as a tenant, if you have one of those, this is one of those powers that the state is giving you to let them off, let them go. But another issue that landlord face is if you want to get them to go just like that without serving them a certain notice, they can also come back to say you've actually harassing them.
Yes.
You see, that's another thing they can.
That's why landlords have to be quite careful, and we're quite formal, aren't we? In saying Section 21, Section 8, specific notices, because if someone is a tenant or maybe a tenant, I think you've got to be a little bit careful. Unless you're sure that they're not actually a tenant.
That's correct.
Because the cost implications, I've had one of those. My landlord was an estate agency, but they're one of those ones that I said a little bit casual, if you know what I mean. And so they hadn't formalised, and they literally took the tenant's property out of the property and just changed the locks. So then the tenants because they were people who had an idea of their rights, spoke to the relevant people, and then the landlord was forced to let them back into the property.
Of course.
So when we got to trial, we ended up having to deal with issues of costs. And my landlord had to pay quite a lot of money because he unlawfully evicted them. So that's why we're being quite careful, aren't we, in saying that you must serve the correct notice.
That's correct.
That's the first step.
That's the first step. And I think there is one of the client that came to us as well, the same thing, whereby notice were not served correctly, and then you have to apply for an injunction. You see, and as we said, it's cost. So once you apply for an injunction, now we're going to bring a claim for harassment, which is just make the money go up.
I think in the landlord environment, especially right now, it could be seen that it can be very technical, and therefore, I think beginning with the serving of the tenancy agreement, it's always good to make sure you have got everything else covered, including the new laws of the deregulation, which means that even if the tenancy is coming to an end, and you have not served the tenants with some documents, which you ought to have served them at the beginning of the tenancy, you might still struggle to take the tenants out of the property. And that's what most landlords are facing at the moment.
Because of the gas safety certificate, electricity, all of that stuff.
How to rent booklet and things like that. They seem minor, but then when you come to court and the judge could say, you know what, the tenant could actually say, no, I was not served with this, and then that means that the notice itself is faulty. If the notice is faulty, means you cannot obtain possession. You'd have to pay the court fees. You have to pay the other side solicitors. It's a lot of cost which could be avoided by, first of all, finding out the right information you need to give at the beginning, and also if you have any questions, ask find information.
Yeah, ask a
it's-
lawyer. I mean, that's the normal, easy way of doing it, isn't it?
Absolutely.
Yeah, and have you got any sort of examples of where it's gone wrong, as it were? Yeah, I know you nodding along.
Oh yes.
Yes.
Oh yes.
Yeah, of where it's gone wrong, where the tenant or the landlord have done the wrong thing, as it were.
Yes.
Yeah.
I think one of the cases that I have is the landlord issued notice on the rent arrears, and the way he calculated his rent arrears was actually wrong, but to him it was correct. On the tenancy agreement says rent is paid. I think it's like
Monthly. Every 4 weeks.
Every 4 weeks, but then when he was given his rent statement or a rent schedule was monthly. So he tells the tenant that I'm serving you a notice is monthly.
Yes.
But then there's a tenancy agreement is every 4 weeks. Now that makes different. If you do every 4 weeks, it makes different. So now this case end up in court, and then we had an issue because you had to calculate it. The other side was saying, no, if it's every 4 weeks, we don't owe you money because it's every 4 weeks. We don't owe you money. You paid everything. And then we also disputed that it's monthly. So it became...
Yeah, every 4 weeks and a month are two different things.
Two different things.
It's amazing how people think it's not.
Two different things.
28 days versus 30 or 31.
It was quite interesting one. But then I think with that one, my client wasn't successful because he ended up what the judge was saying, the notice was faulty.
Yes.
Because you're supposed to... I think one of the things that he did was he didn't actually say how much arrears. He didn't say that how much arrears are you buying. What he says that it's 2 months rent arrears. But then the other side, Barrister was saying, no, it's not the tenant who need to go and check how much is actually physically in arrears. The landlord
is supposed to say it. So there are a few technicalities.
So you have to say the amount of money which is the arrears, and then you say, okay, it's more than 2 months.
So you're chomping at the bit as though you've got about 1,001 examples.
Yes.
Yeah. Is there any you want to sort of just warn people about in terms of what you've seen as well?
I would say the one that I've seen, which was quite technical, was when the landlord had served Section 21 by themselves. And I think they went to try and get possession, and then it was refused because they said they did not give the due. I think they didn't give EPC certificate.
Okay.
So they had to come back to us, and then we have to look through the documents. And when you look through the documents, you figure, okay, you didn't give that, so let's just give the notice again. But then in that case, the landlord had to pay the other side's legal fees.
Oh, for the first hearing.
Yeah, for the first hearing. Yeah. So, and in that case, it was not nice because it's quite something really minor that could have been avoided, which it wasn't. And also looking into the fact that when you serve the notice, right now, if you make a mistake when serving the notice, you're gonna have to wait 6 months. Before, on the Section 21, it was 2 months.
Yes, exactly.
Section 8 was 14 days. Now, on both, is 6 months.
For the foreseeable, isn't it? I mean,
so therefore, if let's say somebody, if let's say somebody is on arrears for £6,000, if you are serving them notice now, you are looking for another £6,000. That's £12,000. If you are a landlord who has to pay mortgage on that property, how are you going to be surviving, especially right now? So I would say for any landlord, it's imperative that you double check any notice you're giving, make sure that you followed everything you have given, all the documents you need to do, or seek help because you don't want to waste more time, waste more money on those kind of things.
Yeah. No, thank you guys. That's been really informative. I just want to give a shout out to some of the viewers who are watching us. So a shout out to Sandra Kosa, to Jemima Essel, JB Dankwa, and Kofi, Eric, and then Monaheng, Lipakela, I think Monaheng.
That's cool.
And then Letitia Chire, Chris Evans as well, then Thomas Hassan, Stephen Tufor, and Eric again. So thank you everybody for your replies so far. Do ask us questions. I can always come and deal with those questions later if we finish the program, or you can message me privately if there are questions that you want to ask us, okay, and maybe you just don't want it on the public forum, but feel free to ask the questions that are interesting to you. Also, more Mary Canado, hi, good evening, how are you? And then if you do want to ask questions, we actually have put a number up now. It's 07802 627 333. That number again, 07802 627 333. But if you look at our feed, where we're live right now, you'll see the number also on our page, all right? So then you can post your question there. And a last shout out to Prophet Fitzgerald Johnson as well. Thank you so much for watching, and good evening to you as well. So guys, if we get back to the do's and don'ts of possession proceedings, there are, looking at the questions that we were going to ask, what are your rights if the person doesn't move out? And so if you're a landlord and you're renting out property, your tenants, you give them the Section 21 notice or Section 8 notice, you make them aware in writing that they are to leave the property. And the tenant then doesn't leave the property. I think we've already alluded to the fact that we end up in court. And then you have to tell a judge and explain to a judge why you want your property back. But if I leapfrog over that slightly and start looking at the worry of what if after that the tenant just goes, okay, I've been to court, the judge said you're allowed to get your property back. I asked the judge for 14 days, 28 days, 7 days. The judge gave me those days. And I'm still there. I don't want to leave. I love this place. This is my home. I've lived here for 5 years. I've lived here 5 years. I've paid no rent for the past 6 months. This is great. But it happens, doesn't it? Yeah. What happens if you are the landlord and you're pacing up and down outside looking at your lovely home, falling to bits, and then you need to get that person out? What do you advise that the person should do then?
So what happens is once you obtain the possession order, so as you said, normally it's 14 days. The judge will make an order for you to leave the property in 40 days, unless there's a kind of hardship that prevents you from leaving the property within 40 days. So sometimes the judge might give you 28 days. I think the maximum the court can do, the county court can give you is like 6 weeks. That's the maximum they can give you.
Yes.
After that, if the tenant is in a property, then the next thing that you need to do is to apply to the court bailiff. Now the court bailiff, there are two types of them. You can go to the county court bailiff, which is relatively cheap, with that one, but then that's the longest one, because that will take you about 6 to 8 weeks for you to get an appointment for eviction to take place. Or you can go for the high court enforcement, which I think probably is about 2 to 4 weeks.
Yes.
That's quite expensive, that one.
Yeah.
So unless you're a landlord and you want to give more money to the court and get the tenant out as soon as possible, then you can go on the back. Most landlords will use the county court bailiff. So the county court bailiff 6 to 8 weeks, and then they'll come and change the locks, make sure the tenant is out. They'll change the locks, and then you get new keys. I feel before they come, they will tell you to book for a locksmith. Yeah,
because you have to pay for that, won't you?
So a locksmith will need to be and I think there was one I experienced that myself, where I have to go all the way to my client's house, because I always act for the landlords anyway. Okay. So I went all to the client's house, waiting there, and the tenants were in their property.
Oh wow.
And we have to get them out.
Okay.
You see, it was quite sad, when you see that, but at the end of the day, we just have to
you do your job, don't you?
Yeah. So the bailiff came in, showed them the letter, if you serve this letter, you have to leave the property. They were saying they don't know where to go. We now directed to go to Citizen Advice Bureau, speak to them and see if there's anything they can help you, or go to your local council to see what can they do. Then they packed their stuff, locksmith changed the locks, and my client had these keys. That was it. And then we just...
And then you sort of, that's the end of it, isn't it? And I
That
think, as you said, because the county court made it so cheap, significantly cheaper, but take longer, landlords tend to use, I think, the county court base anyway, because they've already spent so much money.
Yeah.
They're really quite reluctant to suddenly put £500 or even above that towards paying for the High Court enforcement officers. Yeah.
But then if you compare the amount that the landlord would have to lose, if let's say they wait for 6 to 8 weeks to get the date, that means they're going to lose probably £3,000 to £4,000 extra.
Yes.
So some landlords would say, you know what, I'd rather pay the £1,000 for the court fee and then get them out as soon as possible. So in a way, it's going to be more money, but then it means a quicker result. And also with the rent arrears, only the danger is that even though there's social housing for the tenants, if they are evicted because of the rent arrears, the local authority are not normally willing to rehouse because they saying that they have made themselves intentionally homeless
because you deliberately didn't pay
rent. You deliberately did not pay your rent. Therefore, they're not going to help you. So in any case, if you do need help, you can access whatever help you need at the earlier stage, so that you don't go over. You don't fall behind on your arrears. So in any way to get help, you need to be on time on your rents, and therefore you can get housing easier.
Do you sorry, Dennis, go on.
Of that as well, you know, to get the High Court enforcement as well, this you have to ask permission from the court. And
yes,
one of the
that's
things,
right.
You know, because you have to ask permission from the court, and you have to convince the court as to why you want to go High Court enforcement as compared to
county court. Yeah.
So you have to just convince the judge. For the judge to give you that leave, you know.
Permission to go there. And does that involve more cost again, Dennis, or not?
No,
or not significant. It's just a procedural thing.
Yes.
So you know, after we've obtained the order, then we now make an application to the court, to the judge, you know, in front of the judge.
Okay, so you can do it all at once, can you? Okay. Okay. Which also will help with the time as well, because it means it doesn't delay too long.
Yes, and I think when you're doing the Section 21 notice, for instance, I think on the form, it actually asks you what else do you need, you know, from the court, so you can add that you know you
want permission. To get the High Court, so get the big boys, as I say, in, rather than the county court. But I think people are probably more intimidated by, because you see on one of the TV channels, isn't there? They do a lot of those types of programs with rogue landlords and something tenants or something. I can't remember the title, but one of those types of programs where you do see, and I agree, it can be quite sad, can't it, when you see that transition from somebody not owing rent, whether willful or not. Normally, people who don't pay their rent, it's normally because there's an issue. Not because they just sat down and don't feel like it. Normally something's come up, and you know, living from hand to mouth, you can kind of see how people get themselves into that. But my advice always to people is to communicate with your landlord. Don't you think so?
Absolutely. Absolutely. Because with the landlord as well, if your tenant is falling behind with rent, you've got obligation to kind of help them maybe apply for
help them to apply for certain things like housing benefits.
As a landlord, you have to be responsible enough to ask them whether they're entitled to some certain sort of some sort of assistance. So in a way, you're going to have to, as much as the tenants have to take steps, as a landlord, you have to take reasonable steps to kind of find out, is there anything I can do to help you? Then as a tenant as well, you need to communicate with your landlord.
Because at the end of the day, you want your money, don't you?
Of course.
And I think if you're sort of hardline as a landlord, with some tenants it will work, but with some tenants it's not, because you can't get blood out of a stone. If they don't have it, then you need to find a way to perhaps start taking some sort of part payments or something. But then the frustration, as you said earlier, Cecilia, is the problem is that you've got other financial obligations yourself. So being all nicey and helping your tenant out and supporting your tenant whilst you're living in a hole, and you'd rather live back in that house, is again, I think, a bit frustrating, isn't it?
It is. I think it's frustrating on the part of the landlord. Landlord might actually want money to pay, their mortgages.
Yes.
Probably they might have, mortgage arrears.
Yes.
That you're not paying them.
Yes.
So what are you expecting?
Yeah.
For the landlord?
Yeah.
You see,
Yeah.
and I think tenants are not looking at those things.
Yeah.
And even are not coming to this, COVID-19 issues.
Yeah.
Whereby, since March
Mm.
until September, when the court was allowed to hear, cases.
That's right. Yeah.
One thing I've heard, and I've seen, like, tenants deliberately don't pay rent
Yes.
because they
Yes.
cannot be.
Yeah. There's also that, isn't there?
Yeah.
Because they suddenly think, oh, good.
I'm not gonna be thrown out.
Yeah. Yeah. I've got an excuse now. I don't need to pay.
Yeah.
I actually need the money for this and that and
Yeah.
whatever else, because the money, in reality, I think for most normal people, what you get, you could always do with a bit more, couldn't you? So if you can avoid paying your rent and use that money in order to, I don't know, do whatever it is you think you need to do alternatively. Some people do take advantage of that, don't they?
Yeah.
Yeah, I do. Sorry, Dennis.
And even
go
like
on.
now that the court is even encouraging landlords to actually say if you know anything about whether the tenant has been affected with the coronavirus.
Wow. Yeah.
It's quite.
Yeah, it's a big obligation on landlords, isn't it? But then this is what we were talking about, I think, before we came on air, where we were talking about social landlords, this sort of social thing, because, and this is all political, isn't it? I think it must start from politics, because if it starts off the government, local government, not having or providing sufficient housing for the need that has arisen. So you've got social tenants, people who are on benefits, people with children who can't afford to pay their bills, or people who come to this country who are here and then say to the council, right, you need to house me. And the council start thinking, right, okay, what do we do with them? We'll put them in local authority housing if we can. If we can't, we then push it onto the private landlords. So the private landlord almost becomes a social landlord, doesn't he? He becomes a landlord for the welfare state.
Yes.
Which I know great landlords, because they think, look, I'm in, this is business for me. I am in the business of making the money I need to make in order to pay my mortgage, and whatever else they need the money for. But then all of a sudden, as you're saying, Dennis, now somebody comes along and says, well, I've got the coronavirus, or I may not have the coronavirus, or whatever the tenant may say. And then whether that be true or not, the landlord suddenly has this huge obligation, which he never had before, without support from government.
Especially like right now, since the whole, I think we were able to start issuing proceedings since 23rd of September.
Yes.
And the calls we'll be getting from the landlords, can I go ahead now? Can I go ahead now?
Yes.
And then we are starting to put the applications back in court, and then at the same time we have to ask them, what's going on with your tenant? Is any have they been affected by coronavirus? And then we have to fill the form to court and say, you know what, this person, we have contacted them and they have been affected like this by coronavirus. So the court as well has to make another decision. Are we going to give the possession?
This is it. And
the whole thing is like now they're tracking the whole.
Exactly. It's up. It's going to be up in the air, isn't it? I don't think this is going to be easy, because the court's going to have some level of sympathy with the tenant who may have had coronavirus, may have had deaths in the family, may have just been laid off from their work, all sorts of things. Versus a landlord who's saying, look, I'm on the verge of losing my home.
Exactly. So where do you cut the balance? The question is like, where do you strike the balance? There's people who genuinely need somewhere to live, but then also there's some people who rely on those property for their own livelihood. So what do we do?
Someone's going to come out of this not happy.
Exactly.
I suspect.
Like now, even on the court proceedings, they even ask you have to now apply for a reactivation notice.
Oh, yes. I had one of those for the first time a few weeks ago, and I went, oh, right.
You have to do that first before.
We
have the case that the court has gave us a date for the hearing. Then they wrote to us back again to say that date is vacated. Because of coronavirus. You see, and now they want us to now apply for reactivation notice to come back again. So you just landlords now actually, it looks as they got a huge responsibility on their shoulders. So you cannot afford to mess up. Issues
because it can take longer. It'll just take longer. You will eventually get the person out. But it's whether you do it pain-free or painful, either through it taking longer or you having to now look for more money. and pay their costs, pay their expenses. I mean, we've not even talked about deposits yet. I'm not even going to go into deposits yet. So we've got that. And when you talked about the reactivation notice, Dennis, what you mean is that because even if you have a case in court, and it was in court before Corona, and because of Corona they said, okay, well, we're going to suspend this. It's not going to happen now. So once the coronavirus and all the things going with it are all lifted, then you can come back to court. But it's not, what you're saying is it's not automatic.
It's not automatic, no.
Once the time, 23rd of September, Cecilia, is done, you then have to send a notice to the court and tell the court that, oh yes, by the way, we want to start the case again now. And if you don't do that, the case will just, I don't know what's going to happen to it in the future either.
And then if you don't, and then, you know, you have to tell, you want to start the case again, and I know he's got coronavirus.
Well, this is, where's it going to end? Where's it going to end?
Because you can't even, like, even if you're a landlord and then your tenant, you call them, have you been affected by coronavirus? Even if they're still they're still going to work, they're still doing their usual thing. Oh yeah, I've been affected. What can I do? So the whole thing is like you can't even prove that they have been affected or not affected, but you have to still contact them and then see how have you been affected.
You have to try and make the attempt, because otherwise you'll end up in a situation where, what are you going to do on the alternative? You can't repossess the property illegally, because we've already said the implications of trying to do that, and we would always dissuade clients from doing that because it's not worth it actually. But then on the other hand, if you then go through the whole process, you don't actually, right here, right now, I don't think you can guarantee to a landlord that I'm going to get your property back for you. Whereas before you could say, tick this box, tick that one, tick that one, you can get your property back, no problem. I don't think now you can say that anymore, can you? With confidence? Right
now, you can, as long as you follow the right procedure.
You think you can? Yes, even despite the corona?
The whole thing is like the court will not hold the landlord's property forever.
That's
true. As long as you follow the right process. Right now, most of our clients, we have reactivated most of the evictions for the bailiffs. We have reactivated most of the court cases that were due to be heard. So we don't believe that the court will not understand that. For example, we've got one of the our clients who applied for bailiff around February. The tenants were in arrears for about around £30,000.
Oh,
so can you imagine? She has been affected that much. So right now the court is going to give us a date and then she's going to get her property back. The problem is, as a landlord, where your tenant do not have money to pay whatever they owe you, you're going to have to bear the whole cost yourself. I think that's only challenging, because most of the tenants will say, no, there's no way of paying. And then there's no way of pursuing them, because some of them don't even work. So as a landlord, you're facing with challenges.
A lot of money being paid out for a lot of things.
However, if they do get a job, you can still get your money back, probably through like attachment of earnings or some other means. So you can still, there's still a hope.
That brings on to one question actually that I hadn't asked. I think it's similar to what you've just said actually, Cecilia. That when I was asked a question earlier that they've heard that there are some landlords who you can get the possession of your property because you want it quickly. You can do all of that and try and get that quickly, and then deal with the debt later. So if there are things like rent arrears from a tenant, rather than bundling it all up in one, because as you say, then there's going to be an argument, I owe you, no I don't owe you, you owe me, no I don't owe you. Rather just simply serve a notice on the tenant, get to court, get them out, because it's all straightforward. I just want my home back, that's all I want. And then after that, start new proceedings, if you want to, depending on how much, to get your rent arrears from the tenant. Is that something you would advise, or something you've seen?
I think with the rent arrears one, I think you can actually make the application to get possession of a property and also to seek money gradually. Of that one. So what we normally do is that we do both at the same time.
Okay. So sorry Dennis to cut you, because I need to ask this, I know you'll go on. Is this two proceedings almost running in tandem with each other at the same time, or are you talking about the same proceeding?
No, it's the same proceedings.
Okay.
So basically, it's the same proceedings. One proceeding, which especially when you go on a grant 8. So
Yes.
a grant 8, which is you want to seek possession of property because your tenant hasn't paid you rent for more than 2 months
Yes.
or more than 8 weeks.
Yes.
It doesn't allow you to get money judgment on the same one. But you have to prove to the court that you have the arrears have to be made out. So once the arrears is made out, then the judge will now make an order that money needs to be paid as well within 14 days.
Yes.
So you have to leave the property within 14 days or whatever it is, depending on the hardship as I said before. And also you have to pay the rent arrears as well within 14 days. Now, what happens is that most of our landlords that we have don't actually pursue those ones. But then if you want to pursue it, because the court has already made an order that you have to pay the money within 14 days, you have different options how you want to deal with it. So you can just go and give to debt collectors or bailiff for them to pursue it, or you can still go to, but I don't think you should go to money judgment because you already got it anyway.
Yes.
So the best thing to do, once you get that judgment, then get a bailiff, give it to them, they will now pursue the money and also get the property. The only problem that landlords face in that one is most of the time tenants don't want to give them their forwarding address.
Yep.
So that is a problem. So if the bailiff comes and takes the property, then how do you chase you for the money? Where do you live? We don't know. So now we have to do some tracing. Try to trace that person where he is, and when you find the person, then you get the bailiff to chase them.
Yeah.
It's quite.
And they can then get the money for
in
you.
terms of, so I think it's better to when you are doing the application for the rent arrears, then ask for the money judgment.
Okay.
Because if you do the possession first, you pay the court already.
Yes.
Then you go for money judgment. You have to pay another fee.
Yes. To file the claim, to put the claim in the court.
In the court.
There is a court fee.
Even that's
Yes.
going to go to what you call, I think now it's online.
Money claim.
Online.
Yeah.
You have to do
Yes.
those things. Then the court is also going to charge you fees. Based on the amount of money that you're claiming. Then you have to pay lawyers' fees. So it's better to put those together at the same time. Put at the same time, and then get the money judgment. And if you want to enforce it, then you have the opportunity to enforce it.
I think we can't hear you too well, Dennis. You're softly spoken, so I think we'll just give you the microphone.
So if you want to enforce it,
Yes.
then yes, you got the order.
Okay.
You can do whatever you want to do with your order.
Okay, so if we go on to, so I suppose more anecdotal tales. I think the question I've got now is that what are the common mistakes made by landlords? I know we've touched on a few, such as make sure you've got a tenancy agreement that will make life easier for you. Don't just enter the property and possess it. But if I just talk about common mistakes, what about situations where, for example, a landlord has sent to the tenant the correct documentation saying I want you out, which is a Section 21 or Section 8 notice. Then the tenant says I'm not leaving. Landlord goes to court. That's what we've been talking about. Yes. Landlord gets to court, gets the possession order, which means gets the court to say this is your property, you have the right to have it back within 7, 14, 28 days, whatever it is. And the tenant doesn't then leave at that stage. What about the fact that you have a possession order? Why do you then need to go and get bailiffs or high court enforcement order? If if the court has said within 14 days the person must get out, why can't you just go and get them out?
Yeah, I think. George?
I think it's fine. I think the main thing is you as a landlord entering the premises, there is a possibility that the tenant could claim that you harassed them or you did something just to protect yourself. It's always advisable to get a bailiff because you as a landlord, even though you've got a possession order, you can't physically go into the property and then move the tenants out. Dennis, did you want to add anything?
Yeah, I think The possession order that you get itself, actually, that means the tenancy has ended. That's what that means. It means, on that the tenancy has ended and you have 40 days to leave the property. Now, although the tenancy has ended, you as a landlord, if you go inside the property, then as Cecilia said, the tenant now can come and make issues that you've actually harassed them or you've done anything that damage the property, or you've stolen their property and so forth. So and then they can make a claim against you, which is going to be, I think it's going to be under this protection from eviction or harassment. So you want to avoid that at all costs. Now, to be on the safe side, the best thing to do is to get the court bailiff, because when the court bailiff comes and they do what they have to do, at least you have a peace of mind. You have a peace of mind that you haven't actually entered in the property unlawfully or illegally,
and you're not breaking the law.
You don't break any law. Otherwise, if you go and do yourself, we've got instances whereby tenants are actually making a long list of goods that have been stolen by the landlord. So, and it's not something pleasant that a landlord wants to be in there. The best thing to do, you got your possession, that's fine. You've waited for that long to get a possession. Just wait for the bailiff to come. The bailiff will do their work, and then you get your keys, and that's it.
And that's it. And you never have to worry about the tenant again.
But then the other issue that you also have is, there's a client that you have, which we changed the locks, and he went back in and changed the locks back in.
Ooh. Okay.
Which
is a bit difficult.
That's a bit difficult, that one is a bit difficult. But I think that's on a different thing because
that's a different level of determination.
It is.
I've not come across before.
They just came back in, and if you see the challenge as well, the landlord faces is if let's say tenant does anything that you report to the police, the police will come back and say it's a civil matter. They're not involved.
Yes.
They don't want to do anything.
No.
They say it's a civil matter.
Even though technically you're trying to say the person's now trespassing.
They say it's a civil matter.
Yeah.
They're not involved.
Yeah. Well, that's another government thing. Isn't it? That's another issue.
Yeah.
We've got, if I may, just ask a question. We've got a question from Eric Martha. Eric, evening. Just want to ask this question. Thank you very much for posing this question. The question is, please do you still have to pay your rent when your landlord asks you to move from the property, when he gives you the 3 months notice?
Yes, you have to.
I know, right?
Yes, because I think the reason why you have to pay is because you are seeing the property.
Yes.
You are seeing the property. You haven't moved away. You haven't moved out of the property. The tenancy agreement, that's what we're saying, is better to have a written tenancy agreement, because if that tenancy agreement states that this is how much you need to pay while you're in the property. So if the landlord has given you notice, you are seeing the property, you have to pay their rent. You have to.
I think the other things to be aware of is if you don't pay your rent and the landlord then either uses that against you, or if the landlord then takes a claim out against you and he's determined to get his money, the court can enter a judgment or give him the money that he wants, so force you, because it's in an order, to pay that money. And actually, if you don't, what people sometimes don't realise is that's then a debt. If it's a debt, it's a county court judgment that's against you. When everyone says CCJ, that's what those are. Excuse me. It's when you owe money to somebody and you've not paid it. And if you don't pay it within a certain period of time as well, it stays on your record, doesn't it?
And also that,
what I said initially, sorry.
Okay.
When I say initially that the law gives you, if you owe more than 2 months rent arrears, then the court doesn't have discretion.
Yes.
You see? Now, if the landlord gives you notice and you fail to pay the rent, and it gets to the court is now going to see how much rent arrears that you owe.
Yes.
If it's more than 2 months, then that's it. The court can't say anything. See, it's more than 2 months and then you're gone.
Exactly. I mean, I've certainly had a case where I think we got to court. By the time we got to court, the tenants owed maybe 6 or 7 months. But we had to adjourn the hearing because there were other issues. And the court actually said to the tenant, why are you not paying your rent? And, of course, sitting there and the judge looking at you asking why you're not paying your rent, what are you going to say? I mean, I don't know, I've lost my job or whatever, I don't know. And the court said, right, well, I'm going to put an order whilst we're waiting for the next hearing, that you must pay your rent and you must pay the full rent. So that helps the landlord in some sense, because at least he gets some of the money. It doesn't help the tenant because of course he wanted to spend it and enjoy himself. But then at least it then sorts itself out in that way. And you don't really, I mean, I'd suggest to most people, you don't really want to have a debt hanging over you.
No.
I think for most people, you'd rather it be paid. You'd rather someone else paid it for you.
Absolutely. But I think the whole thing is like here, the good thing is like there's so much help that people can access.
Yes.
It's different from anywhere else. If you have a problem with paying the rent, there's always extra help here. However, on the other hand, if you don't, then it becomes your problem yourself.
Yes.
Because you, first of all, no landlord want to take you because of the reference. Because you need to get a reference to go to the next property. You say, no, don't take that one. It doesn't pay rent. And also the social housing won't take you as well. So it is advisable to pay your rent. I think one classic one that I had when I went to court was a tenant owed probably around 3 months rent, and then she's been paying late for a long time, and then when we went to court, she went to pay about, I think, £100 just so that she's under 2 months. And then because we had already put in that consistent delay in paying rent, it's still another crown that we have applied for. The tenant was furious that the court has actually, I think somebody told us, just pay like a little bit so you can be under.
It's no longer the 2 months that Dennis is talking about.
So
but then we've got what we talked about earlier, which is
persistent delay.
Consistently paying your rent late.
Yes.
It's also a reason.
It's also a reason, yes.
Yeah, because I think one of the things that, probably tenants don't realize that if you don't pay your rent is a breach of a contract of a tenancy agreement. If you persistent delay paying rent, is also a breach of the tenancy agreement.
Even though actually, may I just say, it may not be a specific term it may not be written in your contract that if you pay your rent late, then we will seek to evict you from the property. It doesn't have to be in there. Because remember before you talked about discretionary implied, discretion. It's one of those that the court is aware and it's in the law.
That's correct.
That these are the reasons why a landlord can get his property. So the landlord doesn't have to write it in the tenancy.
No.
Which is why it protects a landlord who doesn't have, for example, the tenancy.
Because that's what we normally do. For instance, if a landlord instructs me to pursue rent arrears, I'll put those grounds. So I'll put ground 8, then I'll put ground 10, and I give ground 11.
Ground 8, 10 and 11 for our viewers being brought. Persistently late,
so persistently
rent arrears,
and the breach of
contract as well.
So
you'd always put them. So even if one doesn't work,
at least
at least out of 3, you're going to
out of 3, whatever. But the only thing that 10, 11 are actually discretionary. So you have to actually work hard on that one. To convince the judge,
because it's not clear.
It's not clear cut.
It could be argued either way.
It could be argued. But you need to pay rent. Well,
what I will say is thank you very, very much to Dennis and Cecilia for coming this evening. It's been a great program. I've seen a lot of comments online, a lot of the people who are commenting saying things like enlightening discussion. Thank you very much to the viewers. Good education from some of the viewers as well. And so I thank everybody who's contributed by asking your questions. As I said, I had a few before we came online, so ask those. For those of you who want to contact me and just ask me, if you like, behind the scenes, a question of what you want to know, and perhaps talk to me privately, my number is 07543 989 940. Okay, that's 07543 989 940. I've just been handed a quick note, and I think this was sort of the way we weren't going, where I've been asked, what about the rights of tenants? Because we've focused, I think, to be fair, on the landlords and the landlord's position, and I think if we're right, we're saying the rights of the tenant, it really depends on the reason why the landlord wants you out of the property, doesn't it? I think I'd say that. Because if the landlord wants you out of the property because you haven't paid your rent, well then your rights are quite minimal, aren't they?
That's correct,
it's only if, for example, the landlord says there's been antisocial behaviour, or you're persistently late in paying your rent, that you as the tenant would then turn around and your rights would be to say to the landlord, well, no, that's not correct. I have paid my rent.
Yeah. And I think what happened is the tenant's right, for them to enjoy the property, have a quiet enjoyment of a property.
Yes.
No landlord coming there every now and then, to disturb them. They need to enjoy the property uninterrupted. So I think that is the right. And also they need to have a place which is human habitable.
Yes.
It has to be good.
Yes, it has been a decent condition.
It has to be a decent condition.
If the landlord says there's supposed to be air conditioning, if the landlord says there's supposed to be central heating, whatever it is that the landlord suggests should be there.
Yes.
If it's not, then you can make a complaint.
I think what I've just seen in most cases that most tenants, especially when there is non-payment of rent, it could be because there's some disrepairs.
Okay.
So in which case, if let's say your property is not in a good condition, that could be another reason why you've
not paid.
You can actually say, you know what, I have not paid the rent. That could be a sort of defense.
Yeah.
To if let's say you look into your rights as a tenant, so that could be another way you can defend that.
Yeah.
Part.
I always disagree with that, though. Actually, in terms of it being a defense, I think you can use it as an excuse, and maybe then there's an issue of whether you want to put a complaint in as well.
I think
before the court.
If you look into the, because let's look at, because right now we're talking about the tenant rights.
Yes.
So if you look at the fact that, let's say there's some good landlords and also there are not so good landlords.
Yeah.
Let's say, for instance, this tenant has got a landlord who just doesn't care whether the property is habitable. There's issues with the property, and then probably the tenant keeps on paying the rent and then telling the landlord, okay, no, I need 1, 2, 3, 4, 5 to be sorted. But the landlord ignores, but then gives pay the rent, and therefore, let's say the tenant decided, okay, no, I'm not going to pay you because the property is not in good condition, and the landlord said, okay, no, now I'm going to save you Section 8 because you didn't pay me for 2 months. Then it goes to court. So the whole thing is like everybody else has to keep their side of the bargain. Hence why the tenancy agreement is important. So the tenant knows what are my obligations, and then the landlord knows what are their obligations. So everybody else knows where they stand. And then if one of them breaks the contract, then everybody else knows what they can rely on, what grounds they can rely on.
And I think in terms of what you said, in terms of the disrepair issues, tenants need to make sure that they bring it to the landlord's attention. Because if you haven't brought it down to attention and you don't want to pay rent, then you are not giving the landlord the opportunity to evict you. Now, if you bring to the landlord's attention, that does not give you the right not to pay rent.
Yeah. Dennis, if I can interrupt you, sorry. I think that I know there's a lot you want to say, and this topic is again another can go on forever. I think we have someone on the line who we perhaps just want to deal with and ask the question. Hello, caller, are you there?
Yes, I am.
Hello, yeah, your name please and where you're calling from.
Yeah, my name is Letitia. I'm actually calling from London.
Okay,
I'm at work now. Yeah.
Well, thank you for calling in, Patricia. Do you want to ask us your question? We'll see if we can help you.
Yes, please. I actually have, I gave my
Hello,
house.
Patricia?
Hello, yeah. Yeah, I actually gave my house to estate agents for 2 years. We signed a contract and the contract was meant to end in March. But after the COVID came in, I gave them notice in December, 3 months notice. But anytime I write to them, they refuse to reply my letters and stuff like that. And they were meant to give me the keys and everything back on March 11th, but they didn't leave the property. So they actually sent me a letter in April and told me that because of the COVID, so they have given it to a tenant, so they cannot move because of the COVID. So I said, okay, I gave them up to August for them to move out. It got to August, and I gave them a reminder again. I keep reminding them every day. Then that August came, and so they refused to move out. So I'm a bit disturbed about it because I wanted to go back into the property. But then it's like I gave it to estate agent and they gave it to the people. I don't even know those people that live in the property. So I'm just concerned, and I just wanted to know if
what to do. Yeah. Okay. Well, I'll hand it over to my guest this evening.
Yeah, I think with this one, the agreement between yourself and the agent is just purely contract. Yeah, it's a contractual. So if the contract has ended, or if you want to break the contract, whatever it is, that's between you and the agent. Once the agent have agreed that the contract is gone, then now you cannot take over the tenant, which is because now the tenant becomes your tenant. You see, it becomes your tenant.
Yeah, because they are still taking the money. The estate agent is still taking money from the tenant.
Yes. So how long? Sorry, let me ask you a question.
Since March, the contract finished since March. But they still get the money and then pay me.
Yeah. So the best way to do now,
even though this thing is expired.
Yeah. The best way to do now is to write to the.
And I asked them to, trigger that Article 21.
Yeah.
But then they keep telling me that the tenants haven't got. They said they have no place to go. The tenant said he really loved my house. He doesn't want to leave.
See,
but then I didn't sign direct contract with them. I signed a contract 2 years with the estate agent. Their name is BDS.
If you just hold on, caller, I think Dennis wants to just ask you a question.
Yeah, is a contract between yourself and agent, is it ended?
Yes, please.
That's
it ended 11th of this year, March.
Okay.
11th March of this year.
And then have you seen the tenancy agreement as well? Have you seen it?
Yeah, the copy.
They refused to give it to me.
Right, okay. No, that's fine.
I asked them so many times. They wouldn't even give me the name of those people that live in the house.
Okay, so what you need to do now, you need to formally finish the agreement between yourself and the agent.
Okay.
Then you now need to write back to the tenant to say you are the landlord of a property.
Okay.
Introduce yourself to them.
Okay.
And then if you want to give them, I'm not sure what is the tenancy agreement between that the agent have given them. I'm not sure what's about. I think it would be very good if, let's say, you can have sight of that. But if not, then you once you formally terminate the agreement between yourself and the agent, then write to the landlord, to the tenant, that probably you want to come for a visit or whatever. You need to just give them notice anyway. You have to give them notice.
Okay.
Then have a word with them. See what they want to do and what you can do. And then if you want to vacate them, or if you want to take possession of the property from there, then you can still use the possession procedures.
I think that's right. I think because if the contract with the estate agents has ended, then you just make it clear to them that it has ended. And then
I didn't terminate it straight, but I let them know that I'm not going to renew the contract for them.
Okay, well,
but then I haven't terminated it. So as you said, I'll put it into writing and tell them that I'm terminating it. So I need my certificate of that for the gas and the electricity and stuff like that. Then I'll demand to have it then.
I mean, it may well be your position is, look, you can set it out. You say that we never renewed our agreement after the 11th of March. I've been asking you for all of these things. You're not giving them to me. So therefore, I'm going to I make it clear to you that our agreement has ended. And I don't need your services anymore. Thank you very much. And you must not take the rent from the tenant anymore.
That's correct.
Otherwise, that will be considered by me to be illegal. You can put it in simple terms. Yeah.
And also to add on that,
I shouldn't take money from the tenant after terminating.
No, you can. What's going to happen is that once you terminate the contract with the agent, then you need to write to the tenant that you are the landlord, and you need to give them your bank details where they should they should not pay you to. So I think it's one of those. I think it's about you have to serve Section 47 and Section 48 notice.
No problem.
You have to serve them.
Oh, that's very, very helpful. I'm so grateful to you guys.
No problem.
It's a very good program that you're doing. Very educative.
Thank you very much.
We appreciate you so much.
Thank you very much, Paula. If there's anything else you need, just contact me through Amiga. Just in case there's something you're not sure about.
Yes. I'm a friend of theirs.
Okay.
All right. Thanks so much for your help.
Thank you very much, Paula.
God bless.
Thank you very much.
Thank you very much. You too.
Thank you. Bye-bye. So thank you very much, Patricia, for that call. Hopefully we've been able to help out.
There's issues with the property, and then probably the tenants keeps on paying the rent, and then you tell the landlord, I need one too.
And then hopefully some of you as well have been able to get some more information. Sorry about that noise. Get some more information from us in relation to that. Dennis, I think we were just finishing off, weren't we? Because we were talking about, before we had our phone call, we were just talking about what about the right of tenants,
Yes.
weren't we? We were just looking at that. And I think, had you finished, or was there something?
No, I
that you
haven't. I
wanted?
haven't finished. I think.
Well, then you go ahead.
Yeah,
then.
the tenant, the right that they have is, the landlord need to repair the property. That's one thing the landlord has to do. If there's any problem that the tenant is facing in the property, in terms of probably the heating is there's no heating, there is a boiler issue, or there are leak or whatever, they have to report it to the landlord, and the landlord has to fix them. If the landlord doesn't fix it within a reasonable time, that's what we say, within a reasonable time, then they have the right to complain to the local council. That's what they can do. They can complain to the local council, and then what the council will do, the council now will come and investigate it, and then serve an improvement notice on the landlord. Once they get the improvement notice, the landlord cannot evict them using Section 21. They can't do that.
Yes.
That's one thing. Once they also complain to the landlord that there's a problem on the property, the landlord cannot evict them either under Section 21.
Yes.
Because it's deemed to be
Retaliatory
breach under the new regulation. So they have to notify the landlord of the problems, and the landlord has to fix it rather than offset it.
Yes.
I'm not going to pay you.
I'm not going to pay the rent because you haven't fixed it. Unless, of course, there's a strict agreement between. Because sometimes the landlord says, "Oh yeah, look, the boiler doesn't work. You're right.
You repair it.
Why don't you repair it or get them to repair it, and then we'll take off 50% from your rent next month or something, or for the next 3 months." But then that is. There
has to be a prior conversation.
And it really should put it in writing. Even if it's kind of casual writing, but put it in writing where it's clear that you agree.
But also, you have to seek, before you do that, you have to seek consent from the landlord in terms of the amount that is going to cost to fix those repairs. Because you might not be able to agree. So before you can do anything, speak to your landlord. Usually, landlords will prefer their tenants to have an honest conversation with them.
Yes.
Because they're all human beings. They just want to do the best, because it's good to have a good relationship between the landlord and the tenant.
I think you've got idealistic view, Cecilia, compared to me, because I'm quite cynical. But I think, no, you're right, though. I think the sensible approach is people need to discuss, need to communicate, need to make sure that they know what they're talking about, and try and work through it. Because at the end of the day, the tenant should know, pay your rent. Landlord should know, make the property habitable for the tenant. And those are the main obligations, I think, that each of the parties have. Each of them have to each other. Did any of you want to say anything as a closing part in terms of tenants' rights or anything? Or I think we've kind of covered them, haven't we? I think So once again, I want to thank Cecilia, and I want to thank Dennis for coming this evening. I'm really grateful to the two of you. Had lots of debates, lots of discussion about all sorts of things, trying to help everybody on both sides to try and understand what their positions are as either landlord and tenant, just to make things a little bit easier for everybody. Because certainly right now, with the coronavirus and everything, it's made it quite challenging for both landlords and tenants, I think. So I want to close by just reminding viewers, those who want to sort of give me a ring if there's anything lingering, for example, Patricia, my number 07543989940, or you can look back on the programme and no doubt it will show you the number. You know that my name is Linda Appiah, and I'm a barrister, and I'm at Vine Court Chambers in London. As I said, I'm always with you every 2 weeks, so the next 2 weeks we'll have another programme. Few possible topics, so I will let you know. I think we'll advertise it in due course so that you know what the topic is, so you can get ready with your questions and the issues that you have in relation to that topic. So once again, thank my guests very much for being with me this evening. And as a close, of course, I want to thank our sponsors as well. So World Remit for all your money transfers, and then Cocksmith Cocktails, their number 07738 285316. Okay. thank you very much, viewers, for being with us this evening. Lively debate, lively discussions, and once again, have a